I'm glad to be here.
Did you check out if you want to
Quality will come back to order. Today is Wednesday, November 19th. The time is 1 p.m. With me this afternoon are Commissioner Larry Soward, Commissioner Dr. Brian Shaw, my name is Buddy Garcia. And our General Counsel is Les Trobin.
We're going to bring up items 1 and 2 together this afternoon. Item 1, ALJ's proposal for decision and order concerning application of Tceq Gulf disposal for underground injection control permits, WDW 410, WW 411, 412, and 413, as well as ALJ's proposal for decision and order concerning the application of Tceq Gulf disposal for industrial solid waste permit 87758. Before I get to the order of presentations,
As is our courtesy here at the Tceq, whenever elected officials or local, state, federal officials make the effort to be here, we give them the opportunity to address us as a courtesy. And with us today is the Honorable Robert Nichols, Senate District 3. You do wish to address the Commission, Senator?
Yes, I do.
Thank you for being here, and please proceed.
Thank you. Chairman Garcia, Commissioner Shaw, Howard. First of all, thank you very much for the opportunity to be here and to speak. I'd also like to thank the Tceq for the opportunity they brought by bringing the public hearing to Montgomery County. We had asked, the county had asked, and y'all delivered, so we really do appreciate that. I will keep my comments brief, as I know Representative Creighton, as well as possibly Representative Eisler is here, and some county commissioners will be speaking as well. I know we're going to be hearing testimony from two different parties related to that. I would like to say that many that are in this room today came here to ask for your help in protecting something very dear to them, very dear to their very existence, and that's water. They've come a long way. I would like to ask everybody in the room who came here in opposition to the permit to stand up. You can sit down. They did come along, and they are scared, and they are concerned. And I believe for a very good reason. Montgomery County has over 400,000 people that live in that county. They are 100% dependent upon their groundwater. The recharge water from Montgomery County then passes into Harris County, where one of the most populated areas of the state that is also very heavily dependent on groundwater. And I have a letter from State Representative Caligari from Harris County, who was also in opposition. I want to enter it into the record. We are aware that recommendations have come to you to issue this permit to discharge wastewater below ground, and that after certain tests have been conducted. You may even feel that based on those recommendations and after you hear these last presentations, that you may have no grounds for denying this permit. However, the mere fact that you do have to vote on this should make you aware that the legislature has empowered you with the authority to reject it or to take other actions if you so choose. You will hear arguments from one side that a leak of waste into the groundwater system cannot happen. You're going to hear arguments from the other side that it might happen. Even if the odds are as slight as getting hit by a bolt of lightning, we all know that occasionally people are struck with lightning. And unlike a contaminated surface field that can be cleaned up, if contamination does occur in the underground water supply, there is no way, absolutely no way that it could be fixed. It is damage of a colossal nature. It cannot be repaired deep in the ground. I believe that when you weigh the public benefits with the public damage or potential damage that might occur, the conclusion is that the risk does not outweigh the reward. I urge you to reject the permit and end this thing today. If at the very minimum you feel that you cannot reject the permit at this time, that at the very least you remand the issue back to SOA until the scientific testing that they recommended, until it is performed and evaluated. Consideration of remanding it back to them until those tests have been done. We rely on you to protect us and our citizens, and with that, I want to thank you for the time that you've given me and the others that you'll hear from.
Thank you, Senator. Are there any questions of Senator Nichols at this time? Thank you to you. If you could leave that with our clerk here. And thank you to the constituents that have come all this way as well. I just want to remind everyone that I realize this is an emotional issue. You've come a long way, but on the signs, if you could refrain from, because we have cameras that are videotaping this, if you could refrain from holding those in front of any cameras and keeping your conduct, your applause or howling, what have you, to a minimum so we can proceed. But I do take very seriously, as do the other commissioners, our responsibility here, Senator, and appreciate you coming all this way, as well as the constituents that make up most of this room.
Thank you very much.
Representative Brandon Creighton is here as well. And did I hear Representative Ron Lasso is here as well? Yeah, if you want to address us, fill out a form after Representative Creighton. We'll let you come up here as well. Please proceed.
I want to speak for Commissioner, Mr. Chairman, Commissioners. I appreciate you hearing us today. I want to speak for Representative Isom as well. Montgomery County is here today with great concerns and high emotion over our future clean water supply. I want to start by saying that I understand your job is difficult. You're the second largest environmental protection agency in the world, second over to the federal EPA. Is that correct? Your task is next. You hold a very powerful position of authority where you're challenged to strike a balance between protecting people and water and at the same time allowing business to proceed. And I understand that balance is difficult to strike. Every level of our Montgomery County community is represented here today in opposition of this permit. We have our citizens, we have our legislative delegation, our county officials, city officials from across the county, our Lone Star Groundwater Conservation District. And I've participated in various town hall meetings and over 61 public speeches across the county in opposition to this well in the past year and a half, and I have not run across, out of thousands of people that I've talked to, one person that is in support of this well. No individual or entity supports this application other than the company that stands to profit. With limited time, I want to attempt to appeal to the good judgment of each of you as TCEQ commissioners by describing a few points, discussing key points I feel to be important, and then I will ask you to deny this application. I want to tell you a little bit about Montgomery County itself quickly. Montgomery County is the county north of Harris. It's a region where 25% of the state of Texas will live by 2010, just a few months from now. From 2000 to 2030, our water supply will have to support a population trend increase from 4 million to almost 8 million people. Montgomery County just became the 10th most populated county in Texas. We're the 4th fastest growing county in Texas. We're the 27th fastest growing county in the United States of America. We're not the 189,000 residents of 1994 when a prior company attempted to permit this same site. We're now 445,000 residents with 75 people per day moving to the new communities located just within a few hundred yards of this proposed well site. Our population density will increase to just under 1 million by 2050. We're growing at 60% a decade. And it's just ill-conceived for the demographic trends in our area to consider the location of this well near the old Conroe oil fields, with upwards of 1,000 wells dating back prior to 1935. Very little information on them, very little record keeping, hundreds of unplugged and abandoned well sites. The aquifer itself, I'm very concerned about. The Texas Water Development Board recognizes that groundwater districts are the preferred method of groundwater management in Texas. The state of Texas, the legislature itself, has mandated that we should support the groundwater districts as the local authority on local groundwater issues. I served on the original Lone Star Groundwater Conservation District Board when the voters confirmed that entity at the polls in 2001 until late 2005, and I currently serve as Vice Chairman of the Texas House of Representatives Natural Resources Committee, where over 80% of our docket deals with water issues across the state. At this point, I want to tell you a little bit about the county itself with regard to the aquifer. We're experiencing subsidence at this time. Parts of our county are sinking. We're also, as permitted, mining the aquifer with regard to the amount of permitted we're currently exceeding the recharge of the aquifer as reported by the USGS, United States Geological Survey. And our largest cone of depression for the aquifer is the I-45 Conroe Woodlands corridor, where the largest influx of growth is occurring, where these proposed well sites are located, and where over 97% of our county relies on groundwater. The last hurdle we need is the burden of placing any further risk on our future water supply in a county like ours, and in this 54-county Gulf Coast aquifer region that extends all the way to the lower Rio Grande Valley. Near this same cone of depression lies the applicant's property, where only a few 100 yards lies in between the old abandoned and unplugged oil wells that I have discussed from the old Conroe oil field locations itself, consisting of wells that date back prior to 1935, a virtual pincushion into our water supply that could allow for migration of this waste, a burden that the applicant still has left unanswered. Herein lies a major concern, the location of the proposed wells. Tceq's project has not been proven safe under the standards of the TCEQ's UIC program. SOL recognizes this and recognized that the modeling inputs were wrong and the groundwater district's information should have been used. Today, the TCEQ does not have the benefit of scientific conclusions. There still needs to be more testing and reworking and recalculation. And I ask you not to gamble with the safety of our citizens in asking us to bear this risk. We filed bills for our pre-filing for the legislature. I'd ask you to allow us and the will of the people to speak in the few short days coming for the legislative session. I would appeal to you to ask for courage today and use your authority to deny the applicant approval for these wells. Thank you very much.
Thank you for being here and for the golf club. Craig Doyle Is he a Montgomery County Precinct Commissioner? Precinct 2 wishes to address the Commissioner? The Commissioner?
Thank you, Mr. Chairman and Commissioners. I appreciate the opportunity.
Commissioner Doyle, I'm sorry. Please allow me to interrupt for a second. I apologize. The county is a party to this case, and as an attorney in the case, it seems inappropriate, and I apologize to the Commissioner for traveling as far. We know we asked warning the Commissioner would like to speak. It seems inappropriate to allow a representative, another representative, different representative of the county interest to speak to the Commission. I understand you might adhere to the courtesy policy in allowing elected officials to speak, but in this case, the Commissioner is actually a party to the case through his representative capacity.
Are you a party to the case?
Montgomery County.
County is.
Yeah, I'm. This is more of a courtesy. If it's okay with you, just an opening. We've done this before, and when folks are party as well, if they're elected, just to give them a courtesy of the folks they represent. Not to take away from the presentation that's to follow, or from yours, if that's okay with some of my commissioners. Is that all right with you?
It just is a precautionary measure and this certainly will be for the presentations coming later on by the parties, to caution to limit information that you're presenting to the closed administrative record that the Commission is limited to consideration today.
I have no technical information to offer, but just a couple of comments if it pleases this.
That'd be fine.
Chairman, thank you again. And Commissioners, I appreciate the opportunity to be here. I don't come to you today as an expert in injection wells, but I don't think that you have to be an expert to recognize the inherent danger of injecting toxic chemicals into the groundwater supply in heavily populated residential areas. In a day and time when I've seen 2-year delays on FM 1488 because a woodpecker was spotted in the forest, we've seen two-year plus delays on I-45 because a salamander was spotted in a creek. It just seems odd to me that we're even considering injecting toxic chemicals near our groundwater supply. And I know that each one of you are appointed by the governor because he trusts your intelligence, he trusts your character, and he trusts your ability to go through the decision-making process. And we're here simply today to appeal to the common sense that each of you obviously abundantly have, but requesting that you deny this permit. Thank you for the opportunity to speak today.
Representative Ice, are you here?
Yes.
I apologize for skipping you. We didn't have a sheet on you, so if you don't mind filling it out when you're done. But
I filled one out.
Thank you for being here.
And no problem. Just happy to be here. In fact, I have a letter from Senator Williams, who was unable to be here, and I'll cover that. And I've got a couple of resolutions that I think somebody else is going to read, but just in case I can move them into the record. And for Senator Williams and myself, thank you for permitting a member to read my remarks. Regrettably, an urgent meeting with 6 county judges prevented Senator Williams from being here, but these are his sentiments as well as mine. In that, they are that we oppose the awarding of any permits to Tceq Gulf Disposal, LLC, for the operation of the Class 1 underground injection control wells in Montgomery County, as well as any permits for a surface wastewater storage and treatment facility. And as you've heard from Senator Nichols and Representative Creighton, that Montgomery County is one of the fastest growing counties in Texas, and our primary water supply does consist of underground aquifers. Contamination of these aquifers with materials such as petroleum distillates, ethylene glycol-based antifreeze, caustic aqueous waste, spent acid, and other waste could be catastrophic, as Senator Nichols so well put. We cannot risk the aquifer's destruction or even partial contamination. In conclusion, we urge you to reject these permits. Groundwater is too valuable a commodity in Montgomery County as well as this state, and I know you are aware of the shortage that is coming statewide, and it's very important. And I think Commissioner Doyle put it very well when we worry more about a salamander or a woodpecker than we do the people that depend on one of our most precious assets, and that's our clean water. And we appreciate the time that you will be spending on this issue, and we certainly appreciate and respect your judgment. and we urge you to reject this permit. Thank you.
Thank you very much. You are elected official with the Woodlands Township, is that correct?
I am, and I will be very brief. I was asked to read two resolutions into the record. If you would like, I can. If it will serve no purpose, I've already furnished copies to you. I am here to represent the 90,000 almost people of the Woodlands. Do you want me to read it, the resolutions, or is that enough?
If you submitted it, it's fine with us.
Okay. I think the main point is that I am here to represent the almost 90,000 folks of the Woodlands directly. I am elected on the township board. I apologize because they have an executive committee meeting this morning and could not attend, the majority could not attend. We're in transition to a new form of government, a unique form of government. And we were, and still are, two of the largest resident owners associations in the state of Texas. At 90,000 people, suffice it to say, there aren't many that have two resident associations and a commercial association. I am here to represent all of those. I am a board member on 6 of the major boards in the Woodlands. Used to be a board member on the water board, attend to the water board directors conference twice a year. Our resolution, suffice to say, simply stress the concern of those residents about their precious drinking water. There are plenty of arguments for injection, but not in a leaky oil field that none of you, no one really knows exactly how many wells there are exactly the condition of each of them, are exactly what is the possibility of upward leakage into our aquifer. We earnestly request that you deny this request and that this petition here, please. And if find another location for it, please. Thank you very much.
Excuse me, could we have more volume? It's very difficult to hear what anybody's saying right here.
I don't think that was an issue of the volume, but if anyone that does speak, please speak up into the mic. That is very helpful. The mic is amplified throughout the room. I don't have any other list of elected officials. I do have a participation form for Commissioner Jerry Eversole, County Commissioner from Harris County, who is in opposition to this application. Has sent a spokesperson, but Ms. Patel, we don't need to hear if the Commissioner is not here, but we do put this down for the record.
And on this,
Chairman, if I may present his signed letter,
That'd be great.
or if I may be allowed to read into the record.
Why don't you just present it so we can get moving? That's more of a courtesy for the elected official that's here. So if you would be happy to receive his correspondence, unless anyone has any questions of Ms. Patel.
Sir, I'm Commissioner Reinhardt. I signed up to speak.
Commissioner of what?
Precinct 4, where the 4 wells are going.
Very well. If you're an elected official and like a minute or two outside of the proceedings.
And I just want to put on the record, this is John Riley, Dan, representative of the applicant, put on the record my objection to giving the party additional time.
Yeah, I'm not looking at this as anything other than the courtesy for them to make a few remarks because they're elected officials. This is not the official record, so thank you again.
Thank you. My name is Ed Reinhardt. I'm Commissioner of Precinct 4, which the 4 wells are going in my precinct. And I've had a lot of experience with the oil patch is what we call it. There's many oil wells, as Brandon stated, that we don't even know where they are. They've never been capped. And in the past, when we had dirt roads over there, we could not even grade the roads for the amount of gas lines that were running through the oil patch. So we had to go back and redo those roads to keep from doing more damage to what we did. And so I'm here today to ask you to reject this because there's no way that anybody can tell how many oil wells are in there that's not capped. I've got a friend of mine that's just north of where the wells are going that works for a company that sends the chemicals out. I talked to him the other day and he said, I would no way like to have what we send out dumped in our community, because their chemicals go to Mount Bellevue. And so I'm here today to ask you, please reject this offer. Thank you.
Thank you, David.
For the proceedings right now, given their positions, and all of these will be made part of today's record of attendance. And I guess moving towards the judges, we have Judge Lawson and Judge Egan here today. We'll speak first, no time limits, followed by the applicant Tceq Gulf Disposal with a 10-minute time limit. Thereafter, the protesting parties, Mr. Gershon, Forsberg, and Walker, 10 minutes to split as they see fit. Executive Director to follow, and OPIC with the applicant may save time for rebuttal. And with that, judges.
Thank you, Thank you, Mr. Chairman and Commissioners and Mr. Trobin. My name is Tom Walston, and this is Kathy Egan, and we are the two administrative law judges from the State Office of Administrative Hearings that heard this case. As you know, there are two permits pending, or matters pending, one for the underground injection wells and a second one for the industrial solid waste permit for the surface facility. Both Judge Egan and I heard all of the case and considered both applications and prepared both proposals for decision. But for efficiency, I'm going to present the proposal for decision concerning the injection wells, and Judge Egan will present the proposal for decision concerning the surface facility. As you know, Tceq's applied for 4 underground injection control permits to authorize 4 Class 1 underground injection wells to dispose of non-hazardous industrial wastewater at a facility located near Conroe in Montgomery County. Montgomery County, the City of Conroe, the Lone Star Groundwater Conservation District, and several aligned individuals oppose the permits. Judge Egan and I recognize and appreciate the concern of the city and the county and the district and the residents about protecting their water supply, and we appreciate that and understand it's an emotional issue. However, in doing our work, Judge Egan and I prepared these proposals for decision based on the evidence that was presented at the hearing. And based on the evidence, we recommend approval of Tceq's application for the underground injection wells with the addition of special conditions requiring relocation of the facility entrance to address traffic concerns and requiring additional fall-off testing and reservoir modeling after the existing well at the site is reperforated and before any injection operations would begin. The 4 proposed wells would be located on approximately 27 acres of land. Tceq purchased this tract in 2005. One of the permits would be for a Class 1 well that already exists at the site. The Commission permitted that well in 1994, and it was completed in 1999 by a previous owner, but it was never placed into operation, and that permit expired in 2004. The remaining 3 permits would be for new wells to be drilled by Tceq. The most seriously contested issue for the well permits is the geology and the reservoir modeling performed by Tceq. Specifically, whether a fault located 4,400 feet south of the site is transmissive, and whether Tceq used appropriate assumptions concerning transmissivity of the formation where the water would be injected, and also this transmissivity of the fault in calculating the cone of influence. The permits, if the permits are granted, Tceq's wells will dispose of non-hazardous wastewater by injection into a geological formation known as the lower Cockfield at an interval between 6,045 and 6,390 feet below the surface. Immediately above the lower Cockfield are the middle and the upper Cockfield formations, but more important, immediately above the upper Cockfield formation is the Jackson Shale Formation. This is a massive formation of marine shells or mudstones with a dough-like consistency, approximately 1,000 feet thick. A core sample from that formation showed it to be an impermeable formation. The Jackson Shale Formation serves as the upper confining unit for the injection zone. The experts agreed that the geology of the area is suitable for the proposed injection wells, and that the Jackson Shale Formation would provide an exceptionally good upper confining unit that would protect underground water supplies above the injection zone. A problem, however, and has been mentioned here by others, is that this proposed facility is located within the area of the large Conroe oil field, which has had approximately 750 producing wells within its boundaries, many of which are now abandoned. Most of the hydrocarbon production of the Conroe oil field was extracted from the upper Cockfield, and those wells penetrated this Jackson Formation, which is the upper confining unit. The concern in this case is whether an abandoned oil well could provide a pathway through the Jackson Shale Formation for injected wastewater to reach drinking water that may be up above. Because of the concern about abandoned oil wells, this commission has rules that require an applicant to perform reservoir modeling to calculate the cone of influence. The cone of influence is the area of pressure increase within the injection zone sufficient to displace a drilling mud plug in an abandoned well and thus create a potential pathway up to drinking water above. In this case, a larger cone of influence would potentially encompass more abandoned wells that would need to be investigated for proper closure and plugging and other information to determine whether it could provide a pathway for wastewater. In this case, Tceq modeled the cone of influence using a permeability factor of 500 millidarcies, while the Lone Star District's expert used 80.9 millidarcies. A higher permeability factor would mean that the injected fluids would essentially spread out more easily, allowing the pressure to drop faster, and you would have a smaller cone of influence. Lower transmissivity factor, which would have resulted in a larger influence and required investigation of other possible abandoned oil wells. The party's experts also disputed whether this fault that is 4,400 feet to the south of the site was laterally transmissive. If it's not laterally transmissive, in other words, if fluids can't go through it, it would basically act as a dam and push the cone of influence farther to the north. The Tceq expert testified that it was transmissive. The Lone Star expert testified that it was not. And frankly, we didn't think that evidence was convincing one way or the other. And so we thought, to be conservative, the modeling should assume that it in fact is not transmissive and would extend the cone of influence farther to the north. Although we found that Tceq should have modeled the cone of influence more conservatively, Judge Egan and I did not find that this would require denial of a permit. In most cases, existing well information is not available. This is a unique case where there's already a well at the site, and the applicant is required to model the cone of influence based on actual information from the well once they drill a well. In this case, Tceq proposes to go in and reperforate this well, which could change some of its characteristics. And so we recommend, the ED recommended, the Public Interest Council agreed, and we recommend that Tceq be required to retest the well with what's called a fall-off test after the well is reperforated, and that this test should be conducted sufficiently to reach out to the fault that's 4,400 feet to the south. I'll back up and add a little bit. The previous testing was not conducted long enough to reach out to that fault to determine whether it was transmissive or not. And that once the results of that testing is known, if there is a change in the calculated cone of influence, that additional possible wells in the area be investigated, or that their injection parameters would have to be reduced to reduce the size of the cone of influence. Other issues were raised by the parties, and they're addressed in detail in the proposal for decision. The parties filed exceptions to the proposal for decision, and we filed written responses. For the most part, those simply re-argued the issues in the case. A few of them did have changes for clarifications, and we agree that those should be made, and that's included in our previous written submission. Judge Egan will now present the proposal for decision on the surface facility, after which we'll be available to answer any questions that you might have. Thank you.
Thank you, Judge.
Should I proceed?
Sure.
Tceq also filed simultaneous with the USC, the underground injection wells request for the surface facility, and it's referred to as the industrial solid waste permit. Again, this is a request for the disposal of non-hazardous industrial wastewater. As mentioned by Judge Ralston, this facility sits on 27 acres that are located on Crichton Road in Montgomery County. However, only 0.33 acres, less than half an acre, is being designated as a surface facility. Currently, the entrance is off of Crichton Road, but as we found in the decision on the UIC, the entrance should be relocated, and we put in a special condition, recommended a special condition that the entrance be relocated so that the entrance to the facility is off of the Farm to Market Road 3083. There are residences that are on Crichton Road. This area is, at one time, was residential, commercial, and industrial, and currently is, but it is rapidly changing to primarily residential and commercial. The surface facility was designed as a secured area. It is designed with equipment suitable to offload truck tankers with the non-hazardous industrial waste, then to process and temporarily store the non-hazardous water waste prior to injecting it into the wells. It has two primary areas, the waste unloading and solids area, where the trucks will unload the wastewater, and solids are going to be removed from the wastewater and will be stored until they can be removed to an off-site landfill. Wastewater is offloaded by the trucks through a hose that is pumped into storage tanks that are located on the main containment area. The main containment area has a concrete floor, a concrete wall that is 2 feet high, 8 inches thick, completely around it. It is designed to be able to hold a simultaneous accumulation of waste from a ruptured tank, their largest ruptured tank, which I believe is 30,000 gallons, and a 100-year, 24-hour storm event, which would be 12 inches of rain. According to Mr. Glaber, the commission expert, the commission had only required that the containment area be sufficient to hold a rupture from the largest tank. There were several challenges to the application, including an initial one that was addressed prior to the hearing, and that was the lack of commission rules for this type of facility. There was also an objection to the inadequacy of the application. The inadequacy of the application was addressed in both of these cases, and it was our position that after the ED had approved and done their technical review, that the application was and had been accepted as complete and adequate, that we began with at that point, and that the issues raised were more substantive issues, and we handled them accordingly. As for the rules, this issue was addressed prior to the hearing, and we found that although there are not many rules, there are enough rules to be able to address the issues in this case, so we denied the request to deny Tceq's application because of a lack of rules or inadequate rules. The other concern raised by interveners was Tceq's failure to adequately account for all possible types of chemicals that could be delivered to its site. Since this is not an operating concern, Tceq does not have any current customers for us to evaluate the chemicals. However, they are not allowed to receive hazardous waste. They are only being authorized to receive non-hazardous industrial waste water. Tceq has holding tanks that are designed both with fiberglass and with steel. They use PVC piping and have outlined in their proposal and their application exactly what will be used. There was some concern that there was no demonstration that possible chemicals except it might not be damaging to these tanks. However, Tceq maintains that if a leak or spill ever occurred, it would be contained because these tanks are in the main containment area, and it is suitable to retain at least their largest tank plus 12 inches of rain. Moreover, they have designed or intend in their application stated that they would be investigating inspecting all of their equipment daily, weekly, and keep logs accordingly. There was some issues concerning the lack of scheduling for plant trucks, for the mixing and storage of tanks, whether or not there would be odor caused by the shaker screen units. All of these were addressed by Tceq in their waste acceptance plan and through the testimony presented at the hearing. It is our understanding from the evidence that there is very little odor that's generated from this type of facility. And as to the proposed design and operation of the surface facility and their acceptance of chemicals, each customer, trucks will not just be allowed to show up and a new client arrive and say we want to deposit this. The customers must submit prior to being accepted the type of waste that they are going to be, wastewater they're going to be delivering, and Tceq will conduct a waste analysis before they ever begin receiving waste from this entity. As a follow-up, when trucks arrive, Tceq plan requires it to inspect the individual loads, to review the waste report, and they also obtain a representative sample of the wastewater and send it to their on-site laboratory for what they call as a fingerprint analysis. It's not a complete analysis, but it gives them some information to determine whether or not it is different than what was supposed to be submitted. As for storm water runoff, the surface facility, the actual surface facility is contained. The loading dock is capable of holding waste from a ruptured truck tanker, which is 5,000 gallons. It has a sump pump to remove any water that accumulates in it, and the main containment area is, of course, contained. Any additional water, Tceq has indicated that they would start pumping into the tanks to remove it if more was necessary. Finally, the interveners contend that Tceq's facility may create a nuisance for the entire community. They're concerned about the unscheduled tanker trucks that may get backed up at the entrance of the facility. As we mentioned before, currently the entrance is on Brighton Road, which is a small county road. We agree that that was an inappropriate road for these trucks to be traveling on. Tceq has indicated that they will change the entrance to the Farm to Market Road, which is a new state highway that is capable of handling this type of traffic. It will, however, have to get approval from Tceq before they can change the entrance to that location. After hearing all the evidence, we found that the permit should be awarded, the application for the permit should be awarded, and we did receive exceptions from all parties in this case, and after considering them, the main recommendation, the only substantive change is that the requirement for the new entrants have to go through a special provision. And 14A, we recommended that that be adopted. If you have any questions, I'd be glad to answer.
Thank you. Any questions of either Judge Walston or Judge Egan at this time? Thank you all for the very concise presentation. Mr. Wall? Mr. John Riley.
Good afternoon, Chairman Garcia, Dr. Shaw, Commissioner Shaw, and Mr. Sauer, First General Counsel Trump. My name is John Riley. I am with the law firm of Vincent & Elkins. I am out of the Austin office here in Texas, and I represent the applicant in this matter, Tceq Gulf Disposal, LLC. With me here today are several representatives of Tceq, including Dr. Lou Ross, who is also one of the witnesses in the case. Let me get to the point as quickly as possible. I expect to speak 4 or 5 minutes at this juncture and then come back after other parties have had the opportunity to speak and continue or use the remainder of my time. But at the outset, I'd like to point out that Tceq generates no waste. The facility itself is a disposal facility. That's what the applicant has proposed. And so for those folks who are here today who are concerned about industrial, non-hazardous waste traveling through Montgomery County, nothing that happens here today will alter that fact. The reality is that as part of our regulatory scheme, certain wastewaters that are generated at industrial facilities are classified as industrial non-hazardous wastewaters, and they are regulated by this commission and other entities. And as a result of that, and as you probably realize, the classification itself does not characterize or indicate the toxicity level of the waste, other than to say they are not hazardous waste as defined by regulation. So as between the hazardous waste or hazardous waste disposal facilities and non-hazardous waste disposal facilities, this is the most benign of the two. The critical issues, I believe, in the case, and as recognized by Tceq in the proposal for decision, are the existing data related to the existing well, WDW 410, which was previously permitted as WDW 315. As pointed out in the proposal for decision, it is atypical or not usual to have actual geological information in these types of cases, because typically, as is the case with the other three wells proposed by Tceq, the wells have not been drilled. In this case, the difference is a well has been drilled. It is Tceq's belief that the well was drilled and completed in the least permeable area, or in a less permeable area than other areas in the rock stratum that they propose to inject. So it is Tceq's proposal that they will reperforate the well, or recomplete the well, and demonstrate that the permeability is on the order of 500 millidarcies as opposed to the 80.9 millidarcies measured by the previous perforation, or in the geology that was previously perforated. Obviously, as pointed out by the ALJs, they recommended or felt as though Tceq could have been more conservative in its modeling assumptions as it pertains to that well, and I want to emphasize that point, that 80.9 millidarcies, to the extent that that's a value to use in any modeling, would relate to the single well, not to the other three wells that Tceq is seeking to permit. The suggestion, though, is that the modeling may not have been as conservative. But let me layer in some of the other aspects of the modeling that is extremely conservative. For instance, the injection rates assumed in the modeling assume 365 days a year, 24 hours a day, the maximum level of 350 gallons per minute, and for 30 years, which is, as a practical matter, very conservative. It is unlikely, if not, I wouldn't say it's absurd, but it is not the reality of a business operation that will operate at maximum flow, maximum capacity for 30 years straight. And that's what it's one of the modeling assumptions. The next modeling assumption I'd like to point out that's very conservative is the gel strength assumptions. And that relates to the gel strength of the mud in an abandoned oil well. And the testimony and the record would show that it is likely that the gel strength is an order of magnitude, or 10 times greater than what was assumed in the modeling. It was also assumed in the modeling that there was a fallback of the mud column, that some 50 feet of mud was not there, it's extremely unlikely that that would be the case, but there was an assumption made to that effect. The thickness of the perforations, the expert Tceq retained to prepare the application used 145 feet, where the total footage of the perforations will actually be more on the order of 340 feet of the formation. The modeling assumes a closed system as opposed to natural conditions. In other words, instead of an open system like a reservoir, as we're proposing to inject into, the closed system assumes a confined space and therefore makes a more conservative assumption, particularly with respect to pressure. And I think that it's, of course, the most conservative assumption that all of the modeling was done in such a manner as to expect a well completed in the lower cockfield. And I'll call your attention to what I believe is Appendix 8.2 to the proposal for decision, and your particular attention to the rock strata or layers beneath the surface where Tceq proposes to inject. It is in the lower cockfield, which, as the name suggests, is might not suggest the middle cockfield, but there's a middle cockfield, and then there's an upper cockfield, and then there's the Jackson Shale Formation, which is a 1,000-foot shale layer. To put this in some perspective, I hope, this discussion over whether the fault to the south is transmissive The discussion among the experts at the hearing was there was an offset or a fault 4,400 feet to the south of the Tceq site. The shale layer that separates those two formations, the lower Cockfield and the middle Cockfield, is a 50-foot shale layer. Some of the experts for the protestants, said that the offset, which I believe, if I recall correctly, was somewhere in the order of 100 feet or so, 120 feet, that offset would smear the shale layer across the rock strata that is permeable and seal the fault. That the fault would be sealed. Now that's a 50-foot shale layer, and there's an irony in that assumption about transmissivity. But the experts for the protestants said a 50-foot shale layer could act as a seal, and that's the assumption that they would like to, who have been made in modeling. The Jackson Shale, the formation that I believe should give this commission the assurance that it needs to issue these permits, is 1,000 feet thick. It was described in the hearing as a shale layer that's much like a Play-Doh substance, that with left unpressured, if you had a well bore that was not plugged or otherwise did not have an intact casing, that the rock strata itself would collapse the well bore and seal the bore. There's been much discussion about the number of wells in this area, but to put that somewhat in perspective too, there are 216,000 active oil and gas wells in Texas. Texas has obviously been a major producer of oil and gas in the domestic United States. I'd also ask you to consider that there are 110 or 100 or so Class 1 injection wells in Texas. A different regulatory program administered by a different agency has about 50,000 Class 2 wells, all of which are authorized to inject oil and gas field waste, many of which, I think the number used at the hearing, testified to at the hearing, was 50 or so that are actively being used in the very same area that we're discussing here in this application. The only difference is they're about 3,000 feet shallower or closer to the surface and therefore closer to the groundwater wells that are currently being used by the communities that are here this afternoon. I'd like to reserve the rest of my time and address some additional points that I expect will be raised by the protestants, or the protestant representatives. And so with that, I'll close and see you in a few minutes. Thank you.
Are there any questions to Mr. Riley at this time? Thank you.
Mr. Chairman, Commissioners, I'm Mike Gershon with Lloyd Gosselin. I represent the Lone Star Groundwater Conservation District, a political subdivision mandated by state law to protect and manage the groundwater resources of all of Montgomery County.
Please, if we could keep the outburst to a minimum through this environment. Thank you. Please go ahead.
Make no mistake about it. Tceq is asking you to ignore the most reliable scientific information you have in front of you, and to set aside one of the most important criteria that they've got to meet and that they can't meet in this case: proper classification of the area of review and presentation of evidence, a significant amount of evidence concerning the area of review. They're asking you instead to make your decision based on their assumptions that the administrative law judges have held to be unreliable. What is the most reliable scientific data? The judges, Judge Walston has already summarized it well. The judges have been clear about it in their fact findings. Fact finding 143 says that the fall-off test on the existing well provides the most reliable information on permeability of the current perforated interval. Finding number 146 says that although Tceq plans to reperforate the existing well, it should have used 80.9 millidarcies permeability measured by the fall-off test of the existing well in its reservoir modeling to calculate that area of review. Fact finding number 154 says that Tceq should have assumed that the major fault just south of the site was not horizontally transmissive for purposes of classifying that area of review. Now the judges applied that science. They applied that data. They looked at the modeling results, and they issued finding 159. Finding 159 concludes that the area of review is 2.7 miles. That area of review is larger than the default 2.5 miles that the applicant, the Tceq, relies upon. Now, I have to draw to your attention Tceq Rule 331.121. That's the core rule at issue in this case. subsection A of that rule mandates, there's no discretion there, it's mandatory that the commission consider a significant amount of detail and evidence, specific, detailed information about the area of review before making a decision on the permit. Now, by Texcom's own admission, there is no evidence in the record. You read their briefings, there is no evidence in the record about that expanded area of review. In fact, they cavalierly say that it was the protestants' responsibility to put on a case about problems within the expanded area of review. That's not right. That's not right at all. The burden is on the applicant, not on the protestants. Protestants bring to your attention that they didn't meet their burden. Now, to grant the application, you've got to focus on that criteria. You've got to ignore the rule. To grant the application, you have to ignore that subsection in 331.121 because you can't consider what isn't before you in the record. That they haven't presented that evidence. They admit that. Now, TCEQ's program is set up to give you the best available data, to give you the best available science to make your decision. The program is set up to require the applicant to present that evidence today, to meet their burden today for the commission to make its decision. Now, we're not in a situation where we're lacking good information. We're in a unique situation because we have an existing well. That existing well has allowed us to take a look at what is the best available science in these types of permit applications. We have a fall-off test. We have a completion report for this well site. Now, Mr. Riley seemed to distinguish the other three wells from the existing well, but come on, it's the same well site on 0.3, less than an acre. The best science is before you. All experts in the case, including Texcom's experts, agree that the results of a fall-off test and a completion report are the most reliable science before us. Bottom line, Texcom hasn't presented its case. They haven't met their burden required by multiple rules, but specifically that subsection A of 331.121. That evidence has to be before you today. Special condition fails. The special condition proposes that there be some opportunity to develop evidence in the future, presumptively after you make a decision. That's a non sequitur. The evidence has to be before you make a decision, to allow you to make a well-informed decision. Texcom is asking you to agree to this back-end review to develop the very evidence that must be before you today. And all outside the scope of due process, with the development of that evidence in a hearing, subject to cross-examination, development of the record, and most importantly, for the opportunity for you, the Commission, to review that evidence. Thank you.
Mr. Chairman, Commissioners, Mr. General Counsel, Mr. Trobman, I want to thank you for this opportunity to speak. I'm in a unique position in that I am here representing the individual protestants in this case, the people who I refer to as my friends and neighbors, who are people who have taken the time out of their lives, the people who have really took the flag up the hill, so to speak, in this matter. My clients are the ones who live next to this proposed facility, the ones who live just a mile or so away from the proposed facility, the ones who will have this material underneath their feet if it is allowed to be injected into the ground. When they first came to me, I was presented with a situation where you've got a company, Texcom, and they're wanting to come into a very populated county and inject this material. The claim is, and the testimony was offered by Mr. Ross, that there's some grand need for this service to be provided in Montgomery County. And I'm anxious for Mr. Riley and Texcom to present all those companies who are here today to tell you that they really need this facility. My guess is that won't take that much of your time. This matter was heard last December. There's no need for this facility in this area. I'm not going to reiterate what's already been said by others. But if you just weigh the circumstances surrounding this situation where you've got a company who is trying to do what good companies do and make money versus the location of this facility, the legislature has charged you with the obligation to look at issues, not just what's going on 5,000 feet underneath the ground, but what's going on the surface with traffic, with odor, with noise. The introduction of 90 to 200 tanker trucks a day, which is contained in the record. So we're going to move the entrance from a dirt road to a high-speed state highway or narrow paved highway at a high rate of speed, where trucks, by Texcom's own witnesses' testimony, are going to have to be backed up in the morning before the facility opens. There's nowhere for them to go but to park along a freeway, or not a freeway, but a highway. These are issues that recent appellate law in Austin has suggested that is part of the public interest analysis that is charged to this commission. And I would ask that you consider those issues, not just what's going on underneath the ground, but you have an entire community, a large community, a growing community fighting this battle. You have uncertain science, experts that disagree, faults that may be transmissive or may not, traffic that may be a problem or may not, odor that may be a problem or may not. Why do we side on the side of, well, let's assume it's not going to be a problem? For my clients and for all of the people here today, I think the cautious step to take and the proper step to take is to deny these permits, let Texcom find a more suitable location for their product or their service, and let them go that way. My clients depend upon this commission to protect their health and safety. And that is what the legislature has charged this commission, and they ask that you exercise that by denying the permits. Thank you.
Y'all could save the applause to the end, maybe that would be.
Mr. Chairman, Commissioners, my name is David Walker, and it's my privilege to serve as Montgomery County Attorney. I stepped up here with a list of the public and community entities that were opposed and are opposed and have issued proclamations in opposition to the application of Tceq. I think it is clear to you, and I think it is sufficient to say all of Montgomery County is opposed to this application. Let me very quickly point out 3 areas of the Texas Water Code, 3 particular sections of Section 27.051 that I believe are critically relevant to your decision. First of all, the well is not in the public interest of 400,000 citizens of Montgomery County. It absolutely is not. Existing rights will be impaired. If those trucks line up on 3083 or Creighton Road to dump that waste, existing property rights will be impaired. There's no question about it.
That's time.
A couple of minutes. Just another couple of minutes. You're given 10 minutes and that time was expired. No worries. Please go ahead.
Thank you, Mr. Chairman. 27.051A3. Both ground and surface fresh water cannot be adequately protected. The science and the math in this case suggest the very decision that the administrative law judges suggest groundwater cannot be adequately protected. That is your statutory mandate, those 3 issues. The math and science in this case, gentlemen, is absolutely, remarkably contested and uncertain. The applicant cannot say how far the waste plume will spread 6,000 feet underground. The administrative law judge's recommendation and specific conditions that they recommend underline that very point. Excuse me for saying so, but to grant the permit in the face of this kind of uncertain science would be irresponsible. In Montgomery County, we would say that is placing the cart way in front of the horse. There are 2 competing interests here. I hope it's evident to you. You have, on the one hand, 400,000 citizens of the state of Texas who are desperately concerned about the quality and the safety of their drinking water. On the other hand, you have a corporation wanting to make a profit. I suggest to you, and I urge you, make your decision in support of those citizens, not in favor of a corporation chasing filthy lucre. In conclusion, let me just say, I respect this commission, I respect your mandate, and let me suggest to you that your job here is to provide good government. A decision in favor of Texcom would not be the provision of good government. Let your decision represent and support the interests of 400,000 citizens. Let your decision provide for the safety and preservation of a critical natural resource. Heaven help us, gentlemen. Deny the application.
Representing the Executive Director. With me today are my co-counsel, John Williams, Karen Scott, and Catherine Flagel from the Office of Permitting, Remediation, and Registration. Four of us are here today on behalf of the Executive Director. The Executive Director participated in the contested case hearing and supports Judge Walston's and Judge Egan's findings and the proposals for decision. The Executive Director is not opposed to including a special permit provision in the WDW permits requiring the applicant to relocate the facility entrance. The Executive Director supports recommendation to include a special provision detailing recompletion and other requirements in draft permit number WDW 410. The Executive Director supports the judge's recommendation to include a special provision in draft permit IHW 87758 requiring the applicant to apply for a modification or amendment to reflect the entrance relocation. And finally, the ED respectfully recommends that the Commissioners adopt the proposals for decision and the orders prepared by the judges, and we are available for your questions. Thank you.
Thank you, Ms. Goss. Is there any questions of staff? Yes, Commissioner Sauer.
When the Executive Director was doing the technical analysis of these applications, was the permitting staff aware of the fault and the issues associated with it?
Commissioner Sauer, the person who handled the geology on this application retired from the agency's working. John Santos retired right after this hearing on the last day of this hearing. So let me discuss in a second with
Commissioners, I'm Catherine Flagel with Waste Funds Division, and as I recall the testimony of my colleague John Santos, the geologist assigned to the project, he was aware of that fault.
Okay, he was aware of it, and I guess I have to assume that being aware of it, he had no concerns about the area of review that the applicant used?
Hearsay.
I mean, let me cut to the chase. I mean, the whole issue here is, you know, if we have the fault that exists, and if it is non-transmissive, then I think certainly the ALJs have said that the cone of influence is a different area than what was actually looked at and researched. So I guess I'm trying to figure out if staff knew the existence of the fault, was there any concern at all about whether we were looking at the appropriate area of review? The testing, the field testing.
Okay, John Santos, the ED's witness in this case, did testify that he concurred with the application analysis of that fault, and there was a great deal of evidence presented during the hearing about the fault. And at the end of the hearing, he still concurred that he did not believe that the fault, let's see, is it transmission or not transmission? I'm not the technical person, I'm the attorney, but he did believe that the application as written was protected.
Any other questions, staff?
Mr. Clerk. Thank you. Good afternoon, Mr. Chairman, Commissioners, General Counsel, and Council, parties. My name is Blas Coy. I'm the Public Interest Counsel of the Commission. My office participated in this hearing. Emily Collins was our attorney director on this case. She's no longer with us. She's now teaching at the University of Pittsburgh School of Law. And by the way, it is, I think today, 31 degrees with snow showers. Our office could generally support the ALJ's reasoning and conclusions in both PFDs, with the exception of the alternatives conclusion on pages 58 and 59 of the UIC PFD and conclusion of law number 42. It is our opinion that TexCom did not provide alternatives with any measure of specificity to allow the Commission to determine whether there is a practical, economic, and feasible alternative to an injection well reasonably available. And for that reason, the permit should be denied. The Texas legislature has conditioned issuance of an injection well permit from Tceq on a finding that the use and installation of the injection well is in the public interest. Tceq's public interest considerations include compliance history and whether a practical, economic, and feasible alternative to injection is reasonably available. If the Commission is required to consider alternative wastewater disposal methods to injection, the applicant has the burden of proof to demonstrate the potential to dispose of the wastewater it plans to accept by other means. We believe neither the application or the evidence in the record supports such a finding. The applicant's attempts to meet its burden on alternatives was primarily by cross-examination of the protestants' witnesses, who had expertise in other disposal methods or expertise in developing the feasibility of these things. On cross-examination, one district witness, Mr. Schul, testified about disposing of Class 1 non-hazardous industrial wastewater at a landfill. There was also discussed the use of publicly owned treatment works as an alternative disposal method. As a general matter, we do not disagree that these alternatives may be feasible, but the witness was not asked about the reasonableness, economics, or practicality of discharge or landfill alternatives. The law requires consideration of economics, practicality, and reasonableness. The applicant's cross-examination may have shown that alternatives exist and they may be feasible, but no testimony was provided specifically based on the applicant's particular proposal. In fact, TexCom did not call the person responsible for drafting the alternative section of the application to the stand, and the person who did testify, the applicant's engineer who signed and sealed the application, did not claim any knowledge of how the alternative section of the application was derived. The Commission needs to be able to consider alternatives with a measure of specificity to carry out the legislative mandate to look at alternative disposal methods. We believe the legislature required a more discerning approach to injection well applications to ensure that the Commission considers whether a practical, economic, and feasible alternative to an injection well is reasonably available for each injection well application. A meaningful review of the public interest implications of the injection well proposal was not done. No expert provided an opinion on which alternative is better than another based on the specific economics, practicality, and reasonableness of TexCom's particular project and particular alternative disposal possibilities in the area. Clearly, the applicant did not carry the burden of proof on this issue. Based on the applicant's failure to meet its burden of proof on alternatives, we disagree with the ALJ's conclusions that sufficient evidence was provided, and we recommend that the Commissioners deny the UIC permit on that ground. However, should the Commission determine to approve the UIC permits, this office agrees with the additional special conditions recommended by the ALJs and the PFDs, including the new fall-off test that is run long enough to have a radius of investigation of 5,400 feet, remodeling and recalculation of the plume, the area reviewed, and the cone of influence using the results of that test, and conducting additional evaluations to make any changes. We also support the ALJ's recommendation for the relocation of the site entrance to the facility from the market 3083. Thank you for the opportunity to comment, and we'll take questions.
Commissioner Sauer, you had a question of staff, which I'd like to at least have my perspective on it. The question was whether the fault that's been identified as the fault to the south of the proposed location, approximately 4,400 feet, whether that was identified to the staff during the course of the application process. And of course it was in the application. The perhaps difference between the witness called on behalf of Lone Star, Mr. Phil Brandt, is that he believes the fault to be non-transmissive, whereas the geologist who prepared the application on behalf of TexCom believes that it is transmissive. Among the items that the geologist pointed to, and particularly was the fact that in the history of the Conroe field, there has not been production of oil and gas from the lower Cock field. There has been production of oil and gas from the upper Cock field, and the geologist pointed out that the oil-water contact in the upper Cock field on each side of the fault was consistent. And according to the geologist's testimony, and that's Dr. Bruce Langus, he believed that that indicated that the fault was transmissive, in addition to his general opinion about the nature of the fault itself and any potential for sealing by displacement of the shale layer between the upper, middle, and lower Cock field. Oddly, the implication, aside from the pressure gradient implications, is that if you assume the fault to be transmissive, it actually extends the plume. In other words, the waste injectate, or the wastewater injected, travels further if the fault is assumed to be transmissive. And
That's time.
Therefore, may I have a few more minutes? I think Mr. Walker has a few more minutes. And therefore, there's two things that are looked at in modeling. One is the pressure gradient, the other is the travel of the injectate. And as far as the traveling of the injectate, that is a more conservative assumption. It's assumed to be transmissive. Secondly, you need both things. You need a 80.9 millidarcy permeability and a non-transmissive fault in order to extend the area of review. So the area of review, the difference, even making those two extremely conservative and probably unjustified assumptions, extends only 0.2 miles, from 2.5 to 2.7. So I submit that's, aside from being extremely conservative, is unreasonable. It's unreasonable to deny the permit application based on the difference between 2.5 and 2.7. Finally, the last point made, if I just have one more minute, by the Office of Public Interest Counsel is that there's not been a sufficient public interest demonstration of the need for this facility. I think those words mean different things in different contexts. For a commercial facility that has no waste, generates no waste, and I need to make that a very significant point here today, that the economics are proven whether the facility is successful or not. Having disposal capacity available certainly must be in the public interest, especially with what you've heard about population growth, and of course associated with population growth is the generation of waste. So I believe that for Tceq, if you evaluate the Tceq side and its proposal in light of those words, it only requires you to look at whether it's reasonable for Tceq to use this property and waste disposal mechanism other than what's been proposed. With that, I'll stop and ask you if you have any questions.
Any other questions? Yes, please, go ahead.
I assume that the middle Cock field and the upper Cock field are permeable.
That's correct.
Well, if you're correct that the fault is laterally transmissive, wouldn't there be a connection between the lower Cock field and the middle Cock field?
Absolutely. Yes, sir.
And then the middle Cock field to the upper Cock field?
Yes, sir.
Which has been the source of production of the oil and gas wells?
Yes, sir.
So a path of migration to the point where oil and gas wells have penetrated.
If you don't assume that gravity takes effect underground. But there is a connection, and so the material could be displaced that would move from the lower to the middle. That's the transmissive would suggest.
Right.
If it is transmissive, of course, all our assumptions are valid, and we've done our modeling and met the rule requirements. But if you're angling towards, Commissioner, what the effect of that would be, it would be that non-hazardous industrial wastewater could travel to the middle Cock field, which there is no oil and gas production from this area, and then through another 1,000 feet to the upper Cock field. And then eventually, in order to go any further, it would have to be produced by an oil and gas.
In which I understand there's no evidence in the record to show that all oil and gas wells have been abandoned and plugged.
They're one or the other. Either they're abandoned, plugged, or active. I'm sorry.
Plug, there's a difference between abandoned and plugged. Abandoned means you walked away from it. It may mean that you plugged it before you walked away. But I think those of us that have been in this business any time at all know that there is a good chance that there are some wells unplugged in that area. So my point is, if there's transmissivity, and it can theoretically, because you're dealing with theory as much as I am, it could get to the upper Cock field and find a well that is unplugged and therefore have a path of migration into the groundwater
No, sir, I disagree. The injectate itself, when we're talking about the difference between the two, the pressure gradient and the injectate is where the liquid goes as opposed to where the pressure dissipates. If the pressure finds an open wellbore through a 1,000-foot shale layer and exerts pressure upward in an abandoned wellbore that's not plugged, an open hole, so to speak, then the potential exists for other material, existing naturally occurring material, to move up that wellbore. Not for the injectate to travel like a pipe up that.
Well, but you don't know in 30 years where that plume may be. You don't know in 30 years where that plume may be.
Well, I think you know that gravity will still apply in 30 years, sir. And so I think that the issue will be where the injectate goes versus where the pressure gradient goes, and what is displaced as a result of pressure versus where the injectate goes.
I guess my point is there's a lot of theory built into this.
And interesting enough, in the USC program, Commissioner Sauer, is one of the few programs that depends on computer modeling, but not exclusively. In fact, it actually requires verification of the assumptions made in the computer modeling. Your rules, and I think the testimony to the effectiveness of the USC program, in your TCEQ's rules 331.45 and 331.65, actually require verification of the assumptions made in the model, unlike other types of applications where there's a heavy dependence on computer modeling. The verification is actually the type of verification that has been recommended by SOA as a condition of issuance this permit, that also, we believe, at the outset was required after we reperforated the one well that we have test data from.
Well, okay, and since you brought that up, let me just ask you a big why. Why didn't you do that as part of the application process? The well existed. I mean, and you had data that the ALJ put in a finding of fact that said that the 89 point, whatever it is, 80.9 was the result of the fall-off test of that well, and yet you used a completely different assumption. Why didn't you take the data and verify what you modeled?
Sir, simply because we don't intend to use the well as it currently exists.
But you said the program requires you to verify. Why didn't you then perforate that well and demonstrate data to support the modeling you did? I mean, it's not only in Montgomery County that we talk about the cart before the horse. I mean, you want us to say, trust us, and we'll come back later and show you we're right. But what if you're wrong?
That is your program. And again,
it's not our program that if you don't show sufficiently whether or not there's going to be adequate protection of the groundwater, then we have to give you a permit.
No, sir, that's correct. And so there are two aspects to your question in my mind. The first is whether the parameters that have been authorized in this permit, namely the gallons per minute that are authorized to be injected, whether those would stand if after the reperforation of the well, if 80 millidarcies is the permeability. I believe the answer is no. That the operating parameters would be reevaluated by the staff, and there would be a new decision of the commission as to what level we might operate.
Wait a minute, a decision by the commission?
Yes, sir. Potentially. I mean, there was a discussion earlier about the lack of due process. I think you have experienced numerous times that any action by the executive director is subject to challenge and could be brought before you on a motion overturning that decision. So like any other decision that you've entertained that is made by the executive director, if there's a motion overturned, it will certainly come before you.
I understand that process, but you're basically asking us to issue a permit with a fundamental question outstanding.
Well, if the question exists, and I suggest it doesn't, then what we don't know, and just like any other application, and just like 3 of the other wells in this application, we don't know the permeability of the rock strata in WDW 410 when it's reperforated. And that will be known through the fall-off test recommended by SOA, just as it would in any other application according to your rules. So it is consistent. As we talked about earlier, typically there is no existing well, and you're permitting an underground injection control well without any data whatsoever. And it's not different really in this case. We're saying that the data that exists is from a perforation that we don't support, and we think we will do better when we reperforate.
Well, I fully expect you to make that argument. But it's not, it is different because you have an existing well into the very formations that you're talking about. And you're trying to argue away the findings of that data, and I understand that. But given the fact that you do have an existing well with an existing fall-off test result, it seems to me that it was your burden to confirm numbers otherwise than what that test was, or confirm that the data of that particular well fall-off test should not be used. You allege they shouldn't be used.
There's other testimony. There is a follow-up test that was conducted that discovered that permeability. And as I said earlier, you need not only that number, 80.9, but you also need a non-transmissive fall of 4,400 feet to the south to alter anything or any part of the application. Make it go from 2.5 to 2.7. But the issue really is that data that we have in hand. If that proves out to be the case, then there's additional process to limit operating parameters. So the point simply is it relates to only one well, one of the 3 or 4 wells proposed by Tceq. The other wells, when they're completed, will also have to be tested for a fall-off test for permeability. And at that time, the commission, and as I said earlier, unique to this program, at least in my experience, is that the commission will have the benefit, speaking in general terms, Commissioner Sauer, the commission will have the benefit of actual testing before any waste is injected. Therefore, in my opinion, the UIC rules are protected, and this particular application is protected as recommended by the Tceq.
Then would you have any problem if we postponed this till you did that and brought your evidence back to us and let us then decide if we agree with you?
Commissioner Sauer, the program doesn't allow for that, but if you think about it, you're asking us essentially to complete your program as it's outlined in the rules, not invent new rules as applicable to this program, but complete the program as outlined in the rules, which is what ZOA has recommended and what we've always thought we'd have to do.
The Office of Public Interest Counsel also mentioned alternate disposal treatment methods. Do you have any comment on that?
There was testimony in the record, and it's actually discussed in the application, about alternative methods of disposal. For industrial, non-hazardous wastewater, there are several. One of the witnesses called on behalf of the Groundwater Conservation District, Mr. Ray Schul, testified to those methods, including landfill disposal as a potential. First, there needs to be solidification of the wastewater through addition of fly ash or other components, and then disposal as a solid in a municipal solid waste landfill. That's one option. That is, of course, in the record. Another option is through delivery or piping to a publicly owned treatment works, or POTW, as we say in PA. A POTW does nothing more than combine the waste stream with other waste streams, domestic wastewater and other types of wastewaters, and then treat that wastewater and deliver it to a surface water facility, or a surface water body, I should say. So the alternatives that were discussed, and this is on cross-examination is laid out by Mr. Coy, as well as discussion in the application itself, that the alternatives, in fact, I know, for instance, that there was testimony about Montgomery County's opposition to a new landfill in Montgomery County. So there's opposition, of course, to most waste disposal facilities, and one, particularly in Montgomery County, is a new Montgomery County, landfill. But we did, and in the record, Mr. Chairman, that the alternatives really also have dangers and threats to the environment. Landfills, of course, have potential for all kinds of things to happen. Those are discussed in front of you commonly. And POTWs, of course, the extent that any constituents are removed from the water as opposed to diluted, the wastewaters are injected or delivered, I should say, to surface water bodies, all of which the state of Texas are used for drinking water. So, as alternatives, they don't seem as protective, and this was, again, the testimony in the record, as protective as injecting it 6,000 feet underground below a 1,000-foot shallow.
Thank you. Any other questions? John Ryan?
I do. I have one. With regard to the modeling, I think we would certainly be at a different place if the modeling were done with the one set of measured data we have. In other words, 80.9 millidarcies as opposed to 500. As you've suggested, the primary change of the as I see it, two critical assumptions that are questioned are dealing with the 80.9 versus 500, and then the transmissivity, the horizontal transmissivity of the fault. If the assumptions had been made, and you've argued that there's give and take with regard to the transmissivity issue, but let's focus on the permeability. Excuse me, the 80.9 versus 500 millidarcies. If the modeling had been done at 500, you said earlier that would have limited potentially the injection rate, not whether or not this was perceived, whether or not approved. If the modeling had been done there and we arrived at a level, I think we'd be a lot more comfort in saying, you go back and do your testing and it comes in at 500, then you can request an amendment to allow to change that. I wonder if you've talked about our rules or our process not allowing to go forward with that testing first and then come back and it doesn't contemplate that. I wonder if it wouldn't be feasible to evaluate based on the 500 millidarcy assumption and see where that brings us in lieu of testing. So I would be comfortable with either remanding this and having testing done to determine what that number really is and see how that affects the modeling, and or do the initial SOA evaluation at 500 versus the 80.9 and get a more conservative number, which then, through demonstration of perforation on this well and other wells, then would bring the opportunity for amendments to that. And I guess I want your comments, and maybe if ED staff can help me if I've missed some of the implications of that.
Commissioner Shaw, as I understand, the more conservative assumption would be to assume 80.9 millidarcies as the permeability. And the reason it's more conservative is for purposes of not injectate traffic, let's keep that aside, but in terms of pressure gradient, when you have less permeable strata, you create greater pressure when you're injecting at the same range. All other things being equal, pressure would be greater, and therefore you would find the bounds of that pressure gradient out farther. And so, as I said earlier, there are a number of different very conservative assumptions that relate to pressure gradient and potential for displacement of any existing mud or any kind of pressure-created influence at higher rock strata. So the 500 millidarcies is the number we used, and we used the most sophisticated model available to evaluate that 500 millidarcies. The other expert, one of the other experts, I think, actually, the only other expert to testify on the matter, Mr. Phil Grant, called by of the Groundwater Conservation District, said that he would have, or he recommended, or he thought we should have used 80.9 millidarcies. My understanding of the rules, there are two aspects that are influenced or that are altered by the more conservative number. First is you calculate the area of review based on, which is AOR, as we refer to it, is referred to in the PFD. That's the area that you look at. Within that area, within that circle, you look at what existing wells are there, as well as other features within that area of review. So without we don't have the transmissivity, the lack of transmissivity of the fault, then nothing changes on the area of review. That there is simply a different assumption put into the model, but it doesn't grow the circle greater than 2.5 miles, which is the area of review already that's been considered. The second aspect is the cone of influence, which is also referenced in the PFD. The cone of influence would change, similar to the area of review. If it exceeded 2.5, then you'd have a new area of review. The cone of influence would change and just be a bigger circle, or a circle bigger than what the applicant described, within the area of review. But the cone of influence would have the same, in my opinion, and I think it's borne out by the record in the PFD, the cone of influence would still consider the same wells that are already in the application, the 500 or so wells that were identified in the application, that all the evidence points to in the record, that those are completed in the upper top field. Some may be in the lower top field, but there's a debate on that. But again, it doesn't really change any of the analysis, other than where the cone of influence, how far the cone of influence goes out from the site. But all the information, nothing particular would be gained by going back and reevaluating the area of review using the 80.9, because it wouldn't grow outside of 2.5 miles.
Can someone from the ED comment on that as well, please?
John Williams, representing the Executive Director. We have put our heads together, and it is possible that Tceq could be authorized to do a reperforation and a pressure fall-off test under a Class 5 test well authorization that could be issued by just the Executive Director. If you choose to remand, then it could be accomplished with just Executive Director's authorization.
Could the other side of that, could the modeling be done assuming 500 instead of 80.9 instead of 500, and or the other modeling concerning the transmissivity to arrive at a worst case scenario, or to determine which is the worst case scenario with regard to the application?
I believe those models were presented by the Groundwater District's geologist as well as Mr. Riley's geologist, the two contrast at the hearing. So we do have the extremes, yes.
Would those change your recommendation on the protectiveness of this permit?
No. We still believe it's protective of human health, safety, and environment.
So to make sure I'm hearing you clearly, your recommendation on the protectiveness of this permit would not be altered if the permeability instead of being 500 were 80.9, nor if the horizontal permissivity of the fault was found to be impermeable, and I get my terms mixed up here, if it was non-transmissive. Thank you.
Mr. Shaw, again, those extreme models were both presented at the hearing. The ALJs heard it, our witnesses heard it, and it does not change our position.
Commissioner Shaw, if I may, there's one thing that might add some clarity to this. The rules don't anticipate that we're going to be working with the well that's already been drilled. These rules that we're looking at anticipate having the modeling, drilling the well, doing the pressure fall-off test. It goes back to the Executive Director for review, and then if necessary to initiate corrective action if there might be any other artificial penetrations in the area of review. At that time, in the cone of influence, that is what Mr. Riley was referring to as the due process that's then available. That's any assistance. Thank you.
That certainly is educational for me. With regard to the field, and I'm not sure if Mr. Riley or you should, he made a statement, I believe, earlier, and so I'll ask you if you know. The number of other UICs in this area that exist, are there others that we have permitted in this well field?
The other wells that Mr. Riley referred to are the wells that are permitted by the Railroad Commission. We don't have any permits in that level.
Make sure I'm clear on this process. I understand that typically this would be done as you laid out without the existence of data. In this case, we have data, and basically this is not an unusual path that we would take, except that we already have some insight into what that permeability associated with the well might be. If we had not had the existing well, you would be making the same decision based on the same data before you, and would follow the same process laid out in the PFD that the ALJs have delivered, whereby once the permeability was determined, you would then go back in and look at those injection rates to see if that alters the analysis.
Okay. Tceq's view, 500 Darcy's was a conservative number. That's typically what's relied upon in issuing the permits are historical knowledge and availability of data from other sources.
And the point I have there is I always like real data as opposed to what's sort of theorized or what is we found elsewhere. And until or unless we have different data, the best data we have on site is 80.9. So the key thing I was going to make certain is the path that we potentially would be heading down that if 80.9 turns out to be realistic, that one, that we make adjustments accordingly, and maybe two, I was trying to get at, if it really is 80.9, would that change our decision? Because if it's really 80.9, that would change the analysis and recommendation. I feel more comfortable working from the more conservative to make that initial decision, and then if you find data that says it's even better than we thought, let's go in and apply to be able to try to amend our permit to allow us to do more. So again, just trying to make sure that I'm fully understanding the trade-offs we're having here.
Thank you to everyone for all your work on this, Mr. Coy as well. I think my own personal thoughts are to on both item 1 and 2 would be a remand. On item 2, avoid of some regulatory guidance on that surface application. Maybe we can instruct the judge on both with specific remand instructions, but I open this up to my colleagues and to all, as we move forward with this motion, if y'all could keep the applause or outbursts to a minimum so we can move forward here. And this is the point where we as a commission try to come up with a motion to move forward. Colleagues?
I guess I'm a little unclear as far as what you would like to remand to SOA with regard to what they would evaluate at SOA.
On 1 or 2?
I guess I would sort of like to start with 1, I think, to get a good sense. I think that is one that you've been primarily focused on, but if you can elaborate on either.
Well, I was throwing that out there as an option just to avoid having to trying to get to where you were going as well.
I guess I'm a little bit. My initial thought, frankly, was that we would remand to SOA and have them evaluate this permit in light of either the more restrictive of the assumptions and or to get the fall-off test data and evaluate it based on that data. I didn't hear the applicant willing to get that fall-off data initially, so that was where I was heading, but then from what I heard from the ED, they don't see that it would change their evaluation. I guess I could ask the same of the ALJs if they perceive that it had the modeling been done for 500 millidarcies and or non-transmissivity of the fault, would that change your PFD?
I guess maybe you mean with 80.9 millidarcies.
Yes, I'm sorry. If they used 80.9 instead of the 500, thank you.
I think if you assume 80.9 millidarcies and you assume the fault is non-transmissive, you would come up with the result of the modeling performed by Lone Star Groundwater Conservation District. And I guess that would expand the cone of influence. And I would just say at this point, then I don't think we have information on whether there are wells or not in that expanded area. Now, if an investigation was done to determine there are no abandoned wells, or we have identified all the wells and they're plugged, that might make a difference. At this point, it may or may not make a difference, I guess is the answer.
So there are fact issues that would bring into question there because it would expand that area of influence.
Right.
Excuse me, the
cone of influence.
And so that you would be looking for additional wells. So there would be some value in remanding this to you to be able to take evidence with regard to whether the existence or non-existence of other wells and what their impact would be on this.
In that expanded area, correct.
In light of the fact that there's debate and it hasn't been adequately resolved in my mind, the transmissivity or non-transmissivity of the fault, and the fact that the data on the ground from the existing well is 80.9 millidarcies as opposed to the 500 that was used in the modeling, that I would feel much more comfort if we had the evaluation analysis done either with new test data from the well or in the contrary or the alternative based on the more conservative 80.9 millidarcy and non-transmissivity of the fault.
Is that a motion to remand it? We'll take a step.
Can I
add?
I mean, to the extent that a remand would mean not issuing this permit today, I'm supportive of that. I guess I'm concerned. I read the ALJ's proposal for decision and followed it. I thought really well and expected to flip to the last page and see a recommendation of denial based on failure of burden of proof. I was very surprised when I flipped to the last page and it recommended issuance. There's some major issues here that I think the applicant had a burden of proof on that they didn't meet. And remanding it back, of course, will perhaps give us a better record some time from now because the applicant will be given a second chance. I constantly raise the issue of fairness when we do this because had it been the other side, I'm not sure we would have given them a second bite at the apple. And, you know, I hear Mr. Riley talking about our program. Frankly, Senator Nichols and Representative Eisler and Creighton, I encourage you folks to look at our program. There are many times when we have our hands tied by the statutes that the legislature enacts, or we don't have the necessary flexibility to try to deal with very specific issues. And I've been in this business for 30 plus years, and I know that there has always been the preference to dispose of waste by underground injection. Get it out of sight, out of mind. But as we all know, as this estate's growing, we can't continue to treat our groundwater aquifers, no matter what their depth is or what their quality is, as off limits to potential sources of drinking water. Senator, in your area, there's big fights over how we're going to meet the water supply demands of your district. And yet we continue a program where we put waste in areas of potentially threatening our aquifers that someday we may have to drink. And so I think that the entire program, Mr. Riley, needs to be looked at. This is a program that was put in place years past when we didn't have the water supply and demand issues that we have today because of the growth of this state. I think the legislature needs to revisit this entire program and make sure that we really are protecting our groundwater resources if we approve an injection well. That's above my pay grade. That's the senator. So we have to sit here and try to make sense of the statutes and the common sense and science in a legal process, and that's not an easy thing to do. I for one could not vote to issue this permit today because I think that there are sufficient, there's conflicting evidence or there's insufficient evidence for us to make a finding that the ground and surface water, the groundwater would be adequately protected. I think there's insufficient evidence as to whether or not the public interest could be served. I think that there's a real debate about that. I don't think there's very little, if any, evidence on the feasibility of alternatives. And so I think to issue this permit today would fly in the face of some real evidence deficiencies. I would be fine with remanding. I just continue to raise the fairness issue. I think the applicant had a burden of proof. I don't think they met it. But if we want to give them a second chance at the apple, so be it. Deny the permits without prejudice.
Director, with regard to the alternative disposal options, how does this compare with other applicants of this type? Have we been consistent in the level of burden that were required in this described?
Thought about that, though, was because of your suggestion here, whether it would flat out denial or if there is some more information because of the big picture that we're looking at. The other side is we have the attention of some legislators here today who understand the issues that we're facing here today, and I look forward to seeing the legislature tackle some of these as well. But where we are today in trying to assess not only from the judge's perspective, but what the best route would be to make sure that we understand this issue, and because it's going to be in perpetuity something that we're going to deal with, not necessarily here in Montgomery County, but elsewhere. Your thoughts on that, Commissioner Shaw?
You know, as I laid out, I was comfortable with trying to make sure that we had the right data, the best data to evaluate the decision. And I'm not 100% certain that part of the reason that the applicant's assumptions about meeting our burden have to do with what we've expected in the past. You know, we try to minimize the burden associated with the regulatory process, recognizing that it's critical that we do our job well to protect the health environment in the state of Texas, and at the same time we're trying to find ways to minimize parts of that process that aren't beneficial. It sounds like we probably identified some parts of this that maybe needed to be stronger, and so hopefully by one, similar to what you're talking about, I think, Commissioner Chairman, is that we can highlight those things that we would like to have more data about, the things that we think the burden that we want to see being met. And so I don't feel like we're unduly giving another bite at the apple if we send this back for more information. We've not committed to approving anything. We're just trying to get more information to inform that decision. And so along those lines, before I would be prepared to make a motion, I will address item 2 since we've not discussed it in a lot of detail. If indeed we decide to remand to SOA, one of the issues I think that might be helpful in item 2 is making certain that any concern over which chapters we believe would be in play with evaluating item 2 be clarified. And so I guess I would like ED staff to, if you would, to identify the chapters that would be utilized in order to evaluate item number 2 in that decision-making process, so that we remove the ambiguity that may exist if we send this over for additional evidence in the absence of identifying those chapters. Considering 305, 331, and 335.
Does that encompass conclusion of law for
Mr. Soward, I move that we remand the matter back to SOA for item 1 with instructions to abate the hearing in order for the applicant to provide the additional information requested in conclusion of law 51A through I to the ED and to comply with the requirements of Texas Water Code section 27.051D2 pursuant to 30 Texas Administrative Code 80.265. And once the information has been submitted by the applicant to the ED and reviewed by the ED, direct the ALJ to hold a hearing on the new information and draft an amended proposal for decision. Or, hang on a second, because this is going to be something we're going to have to decide at this point, because the 80.9 versus the 500 millidarcies and the transmissivity. Yeah, I guess I want to know, commissioners, what your preference is, if you have one, because
we've already been there, and the applicant dismisses it. I mean, why not require them to do a fall-off test on the well, and then come and take that data and do their reservoir analysis?
My thinking was that would give us a more conservative analysis and force them to be able to prove up why they should have more leniency in the future.
You're assuming it's more conservative than what a new fall-off test would do?
That's correct. Based on the area, a new fall-off test would likely be 500 or greater, which some of the argument that we've heard is with the 80.9, you're going to have higher pressure, more confined. There's some trade-offs there, but you're going to have ostensibly a worst-case scenario in that.
And I assume that contemplates that if the applicant wants to do a fall-off test and work with a different number, they can.
Mr. Chairman, Commissioner Soward, I move that we remand the matter back to SOA with instruction to abate the hearing in order for the applicant to provide, for the analysis to be conducted utilizing the 80.9 millidarcy permeability and assumption that the fault in question is non-transmissive in the horizontal direction, and to hold a hearing with that new modeling, draft amended proposal for decision, and bring that back to the Commission.
Would you accept a friendly amendment to include any relevant evidence on the public interest issue?
I had intended to do that, and I failed to. Thank you. Yes, I would include in that information on the public interest, and it was one of the points that I had, public interest and the alternative disposal options. Item 2, that we remand. Item 2, and direct SOA to utilize chapters 305, 331, and 335 in taking any additional evidence needed to fully consider whether the surface facility permit satisfies applicable standards and issue a supplemental PFD on the ALJ's findings.
Not quarreling with your motion, I would just, similar types of interactions. As you said, that an outward limit, Commissioner Sauer, maybe 6 months. Me too? Well,
That's the ED for any guidance that you might have as far as how long, and or the ALJ's.
We don't know how much time it's going to take. I mean, the company may decide to go do a fall-off test, but I just think we send it back and, as the Supreme Court said, with all deliberate speed, process the hearing and get it back. But I set an arbitrary time. I can't support that.
New preliminary hearing to the...
The Commissioner will now be standing in recess for 5 minutes.
Libby, you can't block the door.
Yep. First of all, your name?
Jennifer Reel.
Spell your first and last name, Jennifer.
Jennifer, last name Reel, Real.
Okay, Jennifer, tell me a little bit about the meeting today. What do you think of the outcome on this?
I think the outcome is just what it's supposed to be. We've left it in the hands of the commissioners to do the right thing, and we're just going to keep our hopes up that they're going to make the right decisions. They saw the inconsistencies, they saw that it was not right, and they wanted more testing. So they've done the right thing by the public at this point. Of course, they should have denied it. They did give them a second chance, which, like you said, they wouldn't do it for the other side. But it is what it is, and we're going to assume that they've done it in the best of the public interest.
Stairs this way.
There's still more room. There's stairs there. Let's go downstairs.
Okay, first of all, name?
Ed Reinhardt.
Spell your last name, man.
R-I-N-E-H-A-R-T.
And you're the Commissioner of Precinct 4?
Yes.
I'm sorry?
Yes.
Okay. Commissioner of Precinct 4, Montgomery County. Tell me what you think of the outcome of this today.
Well, I wasn't completely satisfied with it, but it gives us another opportunity to go back after them. If you're going to give them an extension and come back, then I think we should have a public hearing to where the citizens will have another shot at them.
What do you think about this going in your precinct? I mean, it's...
I'm not satisfied with it at all, because I don't think they realize what's in the oil patch. I think that they need to think about what's in there. And just like the gentleman said, some wells are capped and some wells are open. So, we need to consider that. I think it's a bad decision to let something like that go in there, not knowing what's underneath that ground.
I mean, you've had problems with roads out there, even just pipes, just basically on the surface of the ground.
Oh yeah, I mean, we couldn't even grade the roads because the pipe was on top of the ground. So we went and overlaid the roads trying to eliminate our problems, and we don't know. We don't know what wells are capped and what wells are not capped. I don't think anyone knows.
What do you think about? Commissioner Doyle came up with the comment there about the salamander and the woodpeckers. Give me a little bit on the inside of that. I mean, that Type 45 up to where we're sitting at right now in traffic.
Yeah, it makes a big difference, that we're going to let something like this go in and then you screw around with a woodpecker, and you object to that, So I don't understand that.
Okay, go ahead.
Well, we had the one incident on 1488 where we had to go back and make it cost us about $45,000, to take care of the woodpecker, and make sure he had a place to live. But then you're going to come back and put injection wells in the ground that affects people's water, and the woodpecker don't affect nobody.
First of all, your name and title, sir.
Brandon Creighton, State Representative, District 16.
Spell your last name.
Creighton.
Tell me, what do you think of the outcome on this?
I think it was a huge victory today. I think the decision by the commissioners to remand shows that the testimony today was very compelling. I felt like coming into today there was probably a 70-30 chance that the applications would be approved to allow the well. So this decision to give us more time is especially to allow the legislators to get into session to possibly pass a bill that might help with it as well is a huge victory. So I was really pleased.
Session starts, we're about a month and a half away from session. You think something will be able to get worked out with this and address some of the things they addressed in here today?
Well, we've already, Senator Nichols and myself have already pre-filed some legislation that would deal with it specifically, but it is a legislative process, so there's no guarantees. All we can do is cover it from every angle and make every attempt, and I think we're making good progress.
Okay, sir. First of all, your name?
Kevin Forsberg.
Spell your last name?
F-O-R-S-B-E-R-G.
And who are you with?
I'm a private practice.
Okay. Tell me your opinion on the ruling today and what you think was fair.
I represent the individuals who have been fighting this battle since the beginning, and I think while they're disappointed that the permits were not outright denied, I think they're certainly happy with the decision today to at least send it back to the administrative judges for a review of additional evidence, and it means more time that this company will not be able to push this material into the ground.
Now, what about the single well they have right now? Are they able to use that one well right now?
No, that well is not permitted. That was permitted by a prior company in the 90s. That permit was expired before Tceq had even bought the property.
Okay, now the ruling today, what actually does this mean now? They're going to...
It essentially means that they have sent the case back to the State Office of Administrative Hearings, the judges who initially suggested approval of the permits for additional evidence, essentially a new trial on 3 or 4 elements of the evidence that they wanted to see more information about. So essentially we're going to have a new trial.
Yeah, I mean, the comments from one of the commissioners there, he kind of looked at it, and after hearing it, looked through the documents and everything from the administrative judges, and he said he flipped to the back page, thought he'd see a page of denial, and it was the opposite way around. Do you think it's going to be fair?
Oh, I mean, we can only hope. We're getting our opportunity to present the evidence, present more information that they want specific information about. I think as the commissioners said themselves, the system is flawed, but we're doing the best to maintain fairness for everyone through the system.
And you've seen, we had, Senator there today, 2 state representatives, plus several county officials. You think, there are quite a few comments noted toward the state legislators and the senator as far as getting some things passed.
Absolutely.
Do you think this will kind of push that a little bit?
I believe so. I believe Mr. Representative Creighton has spearheaded efforts to get additional legislation started. And I think clearly the commissioners are seeking additional guidance from the legislature, and hopefully with that type of information and effort, they'll get something done.
Appreciate it. Thank you very much.
Channel 13. Smile, it's Channel 13.
What do y'all think of the decision today?
It was good. It was pretty good. It was better than the alternative.
First of all, what is your name?
My name is Michelle Duffy.
D-U-F-F-Y?
Yes.
Michelle, tell me what you think of the decision today.
Well, I think the decision today really lacked any kind of teeth, and I wish that the TCEQ commissioners had voted against it. I feel that Tceq had plenty of time and all the resources and cards in their side. They had plenty of time to do what they had to do, and they failed to do it in the time frame allotted, and they shouldn't have been given extra time. Even in the interest of fairness, they had plenty of time to do what they had to do. So I really wish they had just said no, and maybe ask the Tceq owners whether or not they would like these toxic wells in their backyard. I wish that question had come up today.
What part of town? Where are you?
I live in the Woodlands. I live in Panther Creek in the Woodlands, Texas. And I will be coming back and fighting this along with all of the other Conroe and Woodlands residents until we get the way of the people heard and done.
What do you think about the points the commissioner brought up on what was missing out of there and his views on it?
Well, I thought that some of it was very substantive, and I thought that, basically the commissioners had an opportunity today to really vote, instead of always being so concerned about issuing permits to companies, to really vote instead for the health and public safety of the citizens and taxpayers of this country, of this state. And I feel that they did not live up to that expectation, and their duty is, a commission that is appointed by by elected officials. So I'm hoping that the legislation that comes up in January will help protect the citizens of Texas, and not just the citizens in Woodlands and Conroe and Magnolia and Houston, but all the citizens of Texas, because there are these sorts of wells all over the state, and they need to just not happen here.